Welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we have a number of important issues to discuss. I want to begin by wishing each and every one of you a very prosperous and successful 2025. This is the first program for the year, and I want to take this opportunity to put on the record my best wishes for you and your family. May the year 2025 realize all of our dreams, all of our aspirations, and bring us good health and happiness. I want to welcome all of our viewers who are joining us on television from West Coast Berbice. Welcome to another program of Issues in the News. To our viewers who are joining us again on television, this time across the Berbice River from region number 6 along the east bank of the Berbice River, New Amsterdam, Kanji, along the Quarantine Coast, all the way up the Quarantine River to Oriala, Siparuta. Welcome to another program of Issues in the News. To the thousands of you who are joining us on Facebook Live right across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, and as far as Australia, welcome to another program of Issues in the News. And I want to share with you a little secret. 2025 will mark the 10th year that Issues in the News is being aired every Tuesday night. This is our 10th anniversary. I can't believe how quick time flies. In 2015, I started this program, and now we are in 2025. 10 years, an entire decade, has flown past us since the start of this program. I will be bold to say that this is now perhaps the longest running program of its type consecutively in Guyana, or at least one of the longest running programs of this type in Guyana. 10 years without a break. So I want to thank you very much for being with me for the past 10 years. I know some of you. I can recall your names. I have been seeing you, your names on this screen, 10 years now. So congratulations to you for staying with me for the past 10 years. And of course, we have built quite a formidable audience, not only across Guyana, but across the regional and international stage. Anywhere I go, persons meet me, whichever country I go, whichever continent I go, and they tell me that they look at issues in the news when they have the time. So we are, in our small way, making an impact and making a contribution. And that is what this program is about. While the program remains a political program, I try as far as possible to make it as educational as possible so that we can learn from this engagement. And that is why I keep engaging you and I keep encouraging you to share the program, share the live so that as many of your friends and followers can join us in the discussion. And equally important is my encouragement to you to comment in the comment section, express your views, ask questions, put forward your idea on a particular issue. I may not be able to respond, but later on I go back and I read some of the comments, if not all of them, and I try to incorporate them in my presentation in future programs. But as I said, I would like as far as possible to answer you as we are engaging, and I want the program to remain an engaging program and not a unilateral or monolithic voice of me alone on this side. I would like the program to be as engaging as possible. And later on, I plan to take phone calls from you as well so that we can even become more and more interactive. So thank you very much, and let's start with today's discussion. I am pleased to announce that the bill that is referred to as the oil spill bill is now, the draft of the bill is now completed and has been sent to the office of the president for its examination and for further action. The name of the bill, the long title of the bill, is the Oil Pollution Prevention, Preparedness, Response and Responsibility Bill of 2025. Let me repeat that because it's a long name. The Oil Pollution Prevention, Preparedness, Response and Responsibility Bill of 2025. The Office of the Attorney General has sent the bill today, this evening rather, to the Office of the President for onward transmission. So that task has been completed, at least the draft of it, and discussions will begin on possible changes, etc., as the Office of the President shall direct. So I just want, since it was out there that the bill is at the Attorney General Chambers, I am reporting to you that it has now left the Attorney General Chambers and has gone to the Office of the President, in particular the Office of the Vice President. So, as we enter an election year, the political climate in the country is heating up expectedly. Guyana is a very competitive political environment. Politics in this country is rough, let me say that. It's tough. You have to be strong. The political attacks, they vary from decent to vile. They vary from unconstructive to constructive. And the political climate will intensify. The political environment will heat up this year as we get closer to the elections, which is scheduled to take place in the third quarter of this year, the latter half of this year. So we are seeing emerging new political parties, new persons who are expressing political aspirations and ambitions. And we welcome that. I saw a statement of the Vice President being completely misused and misinterpreted to say that the People's Progressive Party does not encourage multiple political actors and new political actors in the political environment. That is far from the truth. And that is not what the Vice President said. What we would like to see, and what I believe the Vice President said, is that those who wish to enter the political fray must understand that it is a competitive environment. It is an environment that will subject you to intense scrutiny. All of us in the People's Progressive Party are subjected every day to intense public scrutiny, critical scrutiny, sometimes unjustifiable scrutiny. But that is part of the territory. And in Guyana, the criticisms can be brutal, they can be cruel, the attacks are unfounded. We are not saying that we will embark on such course of conduct. All we are saying is that those who wish to enter the political arena must appreciate that their conduct, their background, their record, their reputation, their character, their every activity will be subject to public scrutiny, to political scrutiny, and will be part of the political discourse and will be part of the political competition that will surround the elections. But we maintain that this is a free country, and we have fought hard and long for this freedom and democracy which we enjoy, and we continue to fight for this freedom and this democracy that we enjoy. And therefore we welcome all and sundry. All we say that they will be subject to the type of scrutiny that is now a norm in the Guyanese political environment. And we hope that they can withstand the scrutiny. As the people say, if you can't take the heat, don't enter the kitchen. But people rush into the kitchen. Speaking for myself, I have had my fair share of political attacks. When I entered politics, I was never accused of a wrong. Never accused of a wrong. In politics, they tried to pin a murder charge on me. They charged me with larceny of law books, although the president of the country, my employer, swore an affidavit under oath to say that the payment of the subscription for those law books, which I was paying 15 years prior to my appointment, that the government will continue to pay those subscriptions once I accept the appointment as Attorney General, because that was a condition that I put forward. And the president, the man who offered me the position as Attorney General, said so under oath. They still proceeded to charge me and place me before the courts. I offered to buy the books, give them a brand new set of the books. They refused. They want the books that I have, and I said, I'm not giving you my books. Those are my books. The government of Guyana never had any contract with the publishers of those books. All they did was to pay the subscription in my name. And all the paperwork was there. The Auditor General did an audit of the entire case as requested by the then Attorney General Basil Williams, and found that there was no inappropriateness. The Auditor General found that there was no wrong committed, no accounting irregularity, no offense according to the financial accounting procedures in the public accounting system of this country. The Auditor General did that. Give me a clean bill of health. Give the transaction a clean bill of health. Notwithstanding all of that, Basil Williams instructed the permanent secretary to lodge a complaint with the SOCU, the Special Organized Crime Unit, and instructed that unit to charge me. The permanent secretary at the time resigned because of it. A good lady, good, outstanding public servant. She resigned from the position of permanent secretary. I say that to just give you a glimpse of what one has to go through in the political environment of this country. And the PPP, the People's Progressive Party, is not the party who subject people to that type of conduct. Look at what they did to Dr. Roger Luncheon. Dragged him to Soku in a wheelchair. And I can go through the list of ministers, including the president. 19 fraud charges. For what? Nothing that the president owns. It was for a housing scheme that Guyanese were allotted lands in relation to. Movitang, one of the most splendid entertainment centers in this country. Ashley Singh and Winston Brassington were dragged before the courts in handcuffs and foot cuffs simply because they carried out a decision of a cabinet of which they were part and sold that land after a public tendering process to the investor. Today, tens of thousands of Guyanese go there and they enjoy themselves with their families. But sometimes we must reflect on how these things happen. So when we say that we have fought for freedom in this country and we have fought for democracy, we are not speaking lightly on these matters. From Chetty Jagan in 1950, right down to now, that struggle has never stopped. It has never stopped. And it continues up to today's date. So we in the PPP will never sacrifice this freedom that we cherish so dearly. We will never circumscribe this freedom. We will never destroy this democracy that we fought with other Guyanese so long and hard to establish in this country. I say that simply to say to you that we will never shut out people from entering the political fray. All we are saying to them, that when they come on board, they must understand the scrutiny to which they will be subject. That's all we are saying. So, let me look at your comments quickly. Well, I see some funny comments there being made. Um, you may have seen, you may have seen on the roadways some a device along the highway that is recording, some devices that are recording the speed of your vehicles. And that is being implemented across the major highways of our country. That is part of the e-ticketing system which we will launch very shortly. The contractor, the technical persons, and our legal advisors at the Attorney General Chambers are working together to ensure that the law is complied with, to ensure that the technological mechanisms are in place, and to ensure also that the legal machinery is in place so that when the tickets are generated, they are done so efficiently, they are done so legally, efficiently and legally, and due process is observed. It's a complex exercise because we are moving a process that is manual, and that is manual now and paper driven, to one that is completely electronic. And we have already passed the amendments to the Road Traffic Act, and we now have to build out the machinery that will, the image from the cameras will have to go to a particular place, be examined by a police officer. Once the offense is established, then that machinery will generate the ticket. The ticket will be served electronically and manually, and the ticket will inform you of the court to which you will have to go, either to pay the ticket or to contest the case or defend the case if you feel that you ought not to have been issued with the ticket. Then the other part of it is a payment system that allows for electronic payments, not necessarily only at the courts, but at different payment centers across the country, to make the system as accessible and as convenient as possible. We will have to do some more public education on the system once it becomes, or just before it becomes operational, so that the public would understand. But let me assure you that tremendous energies and efforts have been expended to ensure that the rights of the citizens are observed, that due process is followed, and that that the system works efficiently, and you have several platforms through which you can pay the tickets or challenge the legality of the tickets or the offense for which you are charged. So that is in the pipeline and will be unfolding publicly in a very short time, in a matter of weeks, I think, based upon the level of work that has already been done. You have asked me through the several messages and comments that you have sent me, you have asked me to update you on the election fraud cases. The way, first of all, it is a tragedy that we are entering the year of another election 5 years after the 2020 elections, and these fraud charges which arose from those elections have not seen the light of a trial as yet. That state of affairs, in my humble and respectful view, is an indictment on our criminal justice system. And it continues to be of concern to a wide cross-section of Guyanese, both in Guyana and overseas. And this is an objective narrative. I am not casting blame anywhere. As a citizen of this country, I am saying that it is an indictment on the criminal justice system. But that is where we are. The cases, based upon the last ruling of the newly assigned magistrate, will be tried, the cases will begin de novo, meaning that they will begin from afresh, all the charges. Secondly, the court has invited submissions from both sides on whether the charges should proceed summarily or indictably. I am aware that the prosecution has already made those submissions. The defense counsel has not, the defense team has not filed their submissions as of today. I continue to say that the defense team is deliberately delaying the hearing and determination of these charges. As an aside, but on a related matter, I should inform you that the learned magistrate who had conduct of the matter before and who fell ill, but who never recused herself from the case, is back on the job and continues to hear other cases. And there is no explanation as to why that magistrate is no longer hearing these cases. I don't think that a judge or a magistrate can decide not to hear a case without advancing a reason. This magistrate apparently did so. All the public was told that the magistrate fell ill and the case was assigned to another magistrate, and this magistrate is back on the job. No other explanation. Again, I am not attacking any magistrate or any judicial officer. I am not attacking the judiciary. I am just putting on the record factual narratives. So I hope my comments are not going to be misinterpreted as being attacking of the judiciary or the magistrate. I have not stated here an inaccurate assertion. All I have recited to you are material facts which have occurred. So I want to spend some time on a matter of some importance, which has assumed some currency in the public domain in recent times. And it is the issue of the appointment of a chancellor and the appointment of a chief justice. It is common ground that the persons holding these offices are doing so in acting capacities. It is common ground that they have been holding these offices since the year 2017. It is common ground that the Constitution requires the President to make appointments to these offices, but can only do so with the agreement of the leader of the opposition. I have said at a recent press conference that the issue is one for the President. The President, a few days after, have spoken on the issue. I am not detracting from anything that I have said or that the President has said subsequently. I maintain that it is a matter for the President. It's not a matter for the leader of the opposition. It is the President under the Constitution who must initiate a process in relation to these appointments. It's not the leader of the opposition to initiate the process. But what I want to do tonight is to put this matter into a historical context. Because sometimes we forget the historical evolution of these matters. And it is important that we remind ourselves of the road that these issues have traveled before they arrive at the destination where they are currently at. And in my view, sometimes if we don't re-examine the journey, then we wouldn't fully appreciate the destination. Some persons want us to believe that this situation is a sudden creation, and they want to blame President Ali, as though President Ali is the author of this entire imbroglio. That is not so. It is not so. So in 2001, the Constitution was changed to introduce into the appointment formula the issue of an agreement between the President and the leader of the opposition in respect of an appointment for Chief Justice and an appointment for Chancellor. Before that, it used to be the President making the appointment after consulting with the Leader of the Opposition. In 2001, when we amended the Constitution, we changed it to say that the Chancellor and the Chief Justice shall each be appointed by the President, acting after obtaining the agreement of the Leader of the Opposition. That is what we changed it to. And since we changed it, we have never had an agreement between the President and the Leader of the Opposition in respect of the appointment to the office of Chancellor or the appointment to the office of Chief Justice. And I want to make that very clear. 25 or 24 years now, we have never had this agreement, because that's when we changed the Constitution. But it's a little more than that. I want to walk you through. So in 2001, when the change was made, Chief Justice, the Chancellor was the Honorable Desiree Bernard. When that change was made, the Chancellor was the Honorable Desiree Bernard. The first acting appointment to the office of Chief Justice was that of Justice Karl Singh in 2001. He was appointed to act in that office because of this amendment, because the then Leader of the Opposition, I believe it was Mr. Hoyt, did not offer his agreement. So the acting began with Justice of Appeal at that time, Karl Singh, acting as Chief Justice since 2001. From 2001 to 2005, President Bharat Jagdev made several attempts to get Leader of the Opposition Desmond Hoyt and then Leader of the Opposition Robert Corbyn to get their agreement to confirm in office Justice Karl Singh. That never materialized. So we must understand where the withholding of the agreement first came from. Mr. Hoyt withheld his agreement from the confirmation of Justice Karl Singh, and Mr. Robert Corbyn did so on several occasions. When Chancellor Bernard was elevated to the Caribbean Court of Justice sometime in 2006, I think, Justice Karl Singh was appointed to act as Chancellor, and Justice of Appeal Ian Chang was appointed to act as Chief Justice. Justice Karl Singh was acting 4 years prior, or nearly 5 years as Chief Justice without confirmation, because Mr. Hoyt and Mr. Corbyn refused to offer their agreement. When Justice Desiree Bernard was elevated to the CCJ, Chancellor Desiree Bernard, Justice Karl Singh was put to act as Chancellor, because the Constitution says if there is no agreement, you can appoint one to act instead. So he was appointed to act as Chancellor, and Justice Ian Chang was put to act as Chief Justice. So we had two actors again, and this is in 2005. These two gentlemen acted in those offices. Just Chancellor Karl Singh acted until 2017. 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025, 2026, 2027, 2028, 2029, 2030, 2031, 2032, 2033, 2034, 2035, 2036, 2037, 2038, 2039, 2040, 2041, 2042, 2043, 2044, 2045, 2046, 2047, 2048, 2049, 2050, 2051, 2052, 2053, 2054, 2055, 2056, 2057, 2058, 2059, 2060, 2061, 2062, 2063, 2064, 2065, 2066, 2067, 2068, 2069, 2070, 2071, 2072, 2073, 2074, 2075, 2076, 2077, 2078, 2079, 2080, 2081, 2082, 2083, 2084, 2085, 2086, 2087, 2088, 2089, 2090, 2091, 2092, 2093, 2094, 2095, 2096, 2097, 2098, 2099, 2000, 2001, 2002, 2003, 2004, 2005, 2006, 20 without being confirmed. He retired in 2017. Chief Justice Chang acted from 2006 to 2015. No confirmation. Now let us examine what the President did. President Jagdeo, again, from 2006 to 2011, November 2011, made several attempts again to get Leader of the Opposition, Robert Corbyn, to agree to either of these or both to their confirmation, both Chang and both Karl Singh. There are several letters written by the then head of the Presidential Secretariat, Dr. Roger Luncheon, to Mr. Robert Corbyn, requesting his agreement for the confirmation of Karl Singh as Chancellor and Ian Chang as Chief Justice. Mr. Robert Corbyn repeatedly rejected these requests from the President. Let's fast forward to 2011. December 2011, President Donald Ramotar became President of Guyana. I was appointed Attorney General. Mr. David Granger was the Leader of the Opposition. I sat in no less than 3 to 4 meetings, I can't remember, 3 or 4 meetings. I sat with President Ramotar and Dr. Roger Luncheon, met with Leader of the Opposition, David Granger, on a number of issues, including President Ramotar requesting Leader of the Opposition, David Granger, to offer his agreement for Karl Singh to be appointed as Chancellor and Chief Justice Chang to be appointed as Chief Justice. These men would have been acting now nearly a decade in office. Justice Karl Singh would have been acting, I believe, since 2001 as Chief Justice. Then he went up to Chancellor after acting for 5 years, and he acted nearly a decade, nearly 10 years as Chancellor. By that time, Chief Justice Ian Chang nearly 9 years. I think Karl Singh acted 17 years. Some 17 years. And Justice Ian Chang acted nearly 10 years when President Ramotar was trying to get Leader of the Opposition, David Granger's agreement to confirm them in office. I remember President Ramotar asking for reasons for withholding the agreement. None came forth from President Granger. In fact, President Granger agreed not President Granger, Leader of the Opposition, David Granger agreed in those meetings. And it's reported in the press. Investigative reporters can go and you will see that Leader of the Opposition, David Granger, did not offer any objection, any reason for withholding his agreement. Then in 2017, 2015, Chief Justice Chang departed, retired, never confirmed, acted in that office for nearly 10 years, never confirmed, despite repeated attempts to get different leaders of the opposition who were PNC leaders to give their agreement. Never happened. Justice Karl Singh demitted office in 2017 after acting for nearly 15 years or more. Never got confirmed. The leader of the opposition, being PNC leaders, all withheld their agreements. When Justice Ian Chang left, President Granger was already president. He appointed Madam Justice Yonette Cummings, acting Chief Justice. Never engaged then leader of the opposition, Bharat Jagdeo, to seek his agreement. Never did that. He made a temporary acting appointment. When Chancellor Karl Singh left in 2017, Chief Justice Yonette Cummings, acting, was then promoted to act again as Chancellor. Act again as Chancellor. No agreement was sought with the leader of the opposition, Bharat Jagdeo. When Her Honor was put to act as Chancellor, then Chief Justice Roxanne George was put to act as Chief Justice. Then in 2019, I think, or 2018, there was one attempt by President Granger. He wrote leader of the opposition, Bharat Jagdeo, requesting his agreement to make a Chief Justice who was sitting in Belize the Chancellor of the Judiciary in Guyana, Kenneth Benjamin. He was never prepared to confirm Madam Justice Yonette Cummings as Chancellor. He was prepared to bring in a gentleman who was the Chief Justice of Belize and make him Chancellor. And that couldn't have happened when you read the Constitution. You had to be a judge in Guyana to become Chancellor. And leader of the opposition, Bharat Jagdeo, withheld his agreement. The only time the PPP ever withheld an agreement, it was because there was going to be an unconstitutionality. And also, most significantly, it was none of these two that were being confirmed as Chancellor. I went through this tonight so that you understand the historical narrative. And these Johnny-come-lately who are now expressing views on these matters, they must go and check the archive and the history of how this matter has unfolded. Let me also say to you, and remind you rather, that the thought escaped me. I can't remember what I was going to say. Oh, significantly, it was only in June of 2023, only in June of 2023, that Mr. Aubrey Norton, while we were consulting on the composition of the Judicial Service Commission and the Public and Police Service Commissions, Mr. Aubrey Norton, in those exchange of consultations and those letters that were being exchanged between him and the President, he slipped in one paragraph to say that he is prepared to agree to the appointment of Yonette Cummings as Chancellor and Roxanne George as Chief Justice. He inveigled that in the consultations that we were doing in relation to Police Service Commission and Judicial Service Commission and Public Service Commission, a consultation that was completely irrelevant, he slipped that in. So it was the first time that President Irfan Ali is being told, and the PPP is being told, PPP government is being told, that the leader of the opposition is now prepared to agree to these people. And we said to him in a letter, first of all, these consultations that we are engaged in relate to appointments to the Judicial Service Commission, the Police Service Commission, and the Public Service Commission. They do not relate to Chancellor and Chief Justice. That's the first thing. Secondly, it is the President who must initiate a process in relation to those two appointments. Not the leader of the opposition to signal his agreement out of the blues. And thirdly, not because the leader of the opposition decides after 22 decades and more of a hiatus, the leader of the opposition of that party decides that they will agree that everything must fall into place. That would be usurping the functions of the president. The leader of the opposition can't initiate this process. So the president has spoken on this matter. But I thought that I would walk you through the historical orientation, because I see all manner of allegations and contentions are being advanced now, that it is sexist and it is racist for the appointments not to be made. Well, you had an Indo-Guyanese and you had a Chinese-Guyanese acting there. One acted for 17 years and the other one for 10 years. They were two males. Was it sexist then? Was it racist then? And why did President Granger, those I see Norton and his team and Nigel Hughes and all of them making, I didn't see a single one of them calling on President Granger to confirm these two appointees. He could have done that. He could have initiated a process. He did initiate a process, but not in relation to them. In relation to another gentleman that he wanted to import into the judiciary. Not in relation to these two distinguished jurists. But I didn't hear any of these loud voices now say anything then, but they are conveniently finding their voices now. And of course, they are putting it in their own perspective. And that is why I decided to spend some time tonight to walk you through the history of this matter so that you are in a better frame of mind and a better state to appreciate the issues, but most importantly, to understand whether these people who are making these calls, whether they are genuine or not. And we must ask them the question, are we dealing with personalities or are we dealing with principles? It was okay for Ian Chang to act for 10 years. It was okay for Carl Singh to act for 17 years. We didn't hear any of these voices, but it is not proper for other people to act. And far less period. For far less period. I am not justifying anything. I am just comparing the reality. I am putting to you facts. I am putting to you the historical journey that this matter has traveled. I have said elsewhere that the only country in the world that had a constitutional provision like this in relation to the appointment of a Chief Justice was Pakistan. And they never got the appointment done. They never got the leader of the opposition and the president to agree to the appointment. And they have since changed their constitutional formula. And I believe it's back to where it used to be, that the president must consult with the leader of the opposition. I am not advocating for anything here. I am only giving you a narration of the law and of the constitutional provisions and how they evolve and where there is a comparison. Right now as I speak, there is no comparison to the Guyanese position anywhere else in the world. And that, I believe, by itself speaks volume. I have come to the end of the program, and I want to thank you very much for spending the past hour with me. We have not covered a lot of ground, meaning we have not covered a lot of issues, but I hope that I have examined this issue thoroughly and have given you a proper historical perspective of the road that we have traveled in relation to these important appointments, acting appointments in relation to the Chancellor and the Chief Justice. I want to thank you once again, and please join me next week, Tuesday, as we continue our discourse. May God bless you, and stay healthy, enjoy the rest of the evening, and enjoy the rest of the week. Thank you very much.